So everyone, it's so nice to have you all here with us today. I'm Stephanie Greppo from the Institute for the Study of Human Rights. I would like to thank Waleed and Khadija from the Human Rights Institute at the Law School for hosting the second annual Human Rights Advocates Program Memorial. Yes, today we are all here to honor the memory and legacy of Felipe Michelini of Uruguay. He was a towering figure in the fight for human rights and justice, not only in his home country, but across Latin America and around the globe. He passionately embraced his many roles, appointments, and activities, which ranged from the search for the desaparecidos and the commitment to nunca más, to insisting upon dignity for the victims of human rights abuses. I would just like to share with you two instances that illustrate Felipe's character and commitment to others that are related to his connection to Colombia. In 1990, when he participated in the Human Rights Advocates Program at the Institute for the Study of Human Rights, he befriended everyone in the cohort. When they all went to their respective homes, one of his colleagues from the cohort was put into prison for speaking out about human rights abuses in his home country. Felipe rallied governments across Latin America to speak out about this injustice that was done to his fellow advocate, and this led to the advocate being released. And now my connection to Felipe, I run the Human Rights Advocates Program at ISHR. When I was new many years ago to the program, I received an email from Felipe, and he said, "Hello, I've learned that you're now with ISHR. I would love to come and meet you when I'm next at the UN." And I said, "Great, what works for you? Please let me know and we'll meet." I looked him up after, and I saw all that he was doing around the world in human rights. And I thought, we all know here how hard it is to get from the UN up to Colombia, really to get from anywhere below Midtown to Colombia. He came all the way up here, and he spent 1 hour with me telling me about his time at Colombia, not only in the Human Rights Advocates Program, but a few years after, he returned to Colombia and he earned the LLM in law. So he's also a graduate of Columbia Law. He said to me at the end of our first meeting, "Stephanie, if you don't mind, I will email you every time I'm in New York City. Let me know, how can I be of help, service? Let me know." Do you know, every time he came to New York, he came up to Colombia to meet advocates in the Human Rights Advocates Program. He also met alumni like Bakari Tandia in the 2010 program. The last time I saw him, he spoke at Columbia Law, and afterwards he met with students in the HRAP program that year. So I just hope that that illustrates for you that he was truly a man of his word, and he was someone that cared deeply about other people. And now I'm very happy today to introduce Professor David Donat-Caton from NYU, who worked closely with Felipe for many years, and he will speak about Felipe's legacy. Thank you.
Thank you very much, Stephanie, and thank you very much for the Institute, as well as Columbia Law School, for hosting this important event. I'm really honored to be here. I will try to look back into lessons that I've learned, as well as elements of what continues to be carried through today, because unfortunately the fight for justice and the rule of law continues, not only in Uruguay, of course, but thanks to Felipe, I learned so much about his own country. I know that here in the room there are some fellow Uruguayans, others are connected, and far from me from having these remarks being exhaustive or comprehensive, or even probably fair towards the complexities of the situations of Uruguay. Well, let me start with a fact. People say these are anecdotes, I say these are facts. They happened, so they're not anecdotes, correct? So my best team member at that time in Parliamentarians for Global Action at the end of 2000 went to attend a meeting of Amnesty International in Buenos Aires. And he came back enthusiastic. Said, how did the meeting go? Very well. Who was there? A lot of people. And what is good for us? Oh, we have a new member from Uruguay who is the most outstanding member of parliament I ever met. I said, wow. And of course, I took these things with a sort of a grain of salt, correct? And then I said, okay, next time we organize a meeting, he has to be invited for sure. So that man was Felipe Michelini. He was in his first mandate as a member of parliament. You have there a picture taken more than 10 years after at a meeting that he organized as part of this organization called, and still active, of course. I was at that time a legal officer, Parliamentarians for Global Action. And we were engaged in a global campaign for the entry into force of an entity that, as I speak today, is undergoing very difficult times, the International Criminal Court. I'm sure many of you here are studying international law, international human rights law, international humanitarian law, and international criminal law. And the international criminal law that we teach today in classes is not anymore the one that we used to teach in 2000, because there is a court. There is a court in The Hague, potentially for everyone who would commit crimes under international law. You know, there are governments who contest, who express distrust or refusal for the work of this court. You know, inspired by the work also of Felipe Michelini, I would say what the court is doing today is essentially inevitable. It's the consequence of the crimes being committed on the ground. So, you know, that's where we are today. So we are in a law school. It's my duty to tell you that there is a lot of politicization of the work of the International Criminal Court, which comes from outside players, normally not lawyers. And I think it's our duty to explain to you what the court is doing. So at that time, let me tell you, this was the end of the year 2000, and there was already a professor of international relations, not international law, who had attended a meeting that I had organized earlier in the year. His name was Diputato Felix Lavinia, member of the Partito Colorado, conservative, who had said in the meeting that I organized in Buenos Aires a couple of months before that Felipe had joined, who had said already, the Rome Statute of the International Criminal Court fulfills the goals of the Uruguayan constitution. What is the main goal of a modern constitution, including the Uruguayan constitution? To protect human rights. It's not there on behalf of the state as an abstract entity, it's on behalf of the people who live in the state who deserves to be protected by a constitution. What is the International Criminal Court? It's dealing with those who commit the most serious crimes of concern to the international community as a whole, which are against human rights, by definition. Therefore, there was no incompatibility between the Uruguayan constitution and the Rome Statute of the International Criminal Court. This was the line in 1998 adopted by, at that time, the ambassador to Italy, who led the Uruguayan delegation to the Rome Conference on the Establishment of the ICC, Didier Operti, who then have become also the foreign minister later on. And he was adamantly against the creation of the court, and certainly he didn't want to see Uruguay to join it. That's why Uruguay signed the Rome Statute almost like the United States, almost on the last day. The United States did it on the last day, on the 30th of December 2000, under President Clinton. The State of Israel also ratified on the same date. Other states did the same, including Sudan, by the way. Uruguay did it on the 19th of December, just before Christmas, all right? At that time, of course, the debate was on. But Professor Felix Lavinia managed to convince the President of the Republic, that the court was to fight impunity only for the future, not for the past, which is true. And so as a way of showing a new face, for a modernized face for the Uruguayan democracy, it was not bad, it was good for Uruguay to join the International Criminal Court. So Felipe could not explain all that had been happening until he met my colleague Juan Kim in Buenos Aires in this Amnesty International meeting, and he realized that all this process was triggered by a conference organized by the Parliamentarians for Global Action early on the same year, where Diputado Felix Lavinia for many months was in touch with me thinking, what should I say in this meeting? And he presented a sort of a master class, his legacy, which, by the way, became the legal basis for Paraguay to join the Rome Statute and help some right-wing governments, not Chile, until many years after, to join in the Rome Statute. Today, Latin America is the only continent of the planet completely covered by the jurisdiction of the Rome Statute. The entire of Latin America, including French Guyana, are covered by the territorial jurisdiction of the ICC. It's the only continent in the world that, where you cannot really obtain any impunity. So why Felipe joined? Of course, Felipe Michelini as a specific, I'm pronouncing his name the Italian way, I apologize. And whenever I would pronounce his name, he would say Delle Piane, mentioning the second part of his surname, which came from the mother, also Italian, of Italian origins. In Uruguay, they say Michelini. He realized that it was good to support this struggle, to support this campaign, because while the ICC, joining the ICC constituted a guarantee of non-repetition of what had happened in the 1970s and 1980s during the so-called dirty war, or I would like to call it more precisely, Operation or Plan Condor in Uruguay, Argentina, Chile, Brazil, to a certain extent also Bolivia and Peru, as it came out from a judgment that Felipe commented in 2019, from the Italian Court of Appeals of Rome that condemned to life imprisonment 24 leaders of the Plan Condor or intermediaries, military persons, including 13 Uruguayans. Well, he had grown throughout all his life with a major wound. The wound of a child who saw his father assassinated in 1976 by Plan Condor, by the dictatorship, because 2 years before 1976, Senator Zelmar Michelini had gone to report on the crimes, on the gross violations of human rights perpetrated by the dictatorship, the incoming dictatorship, after that a president had been, history sometimes repeats, a president can be elected democratically and then he can develop into an authoritarian and then dictatorial regime. And he went to speak in Rome, Italy, in the Russell Tribunal, the tribunal on the right of people, People's Rights Tribunal, where he, for the first time, showcased the complexities of the operation to destroy all the institutions that were pre-existing in Uruguay under the rule of law to protect the fundamental rights of citizens and other individuals living in Uruguay. So this assassination took place in Argentina in 1976. Yet this was not, even though, of course, I knew about his own, experience as a political leader, this was never a talking point for him. This was never a starting point of any reasoning. At least in my experience, I'm really reporting you my experience. I worked with him between 2000, end of 2000, beginning of 2001 in reality, and when he died in 2020 during the first wave of the COVID lockdowns. And It was absolutely clear, however, that his vision was to take every possible step to ensure that what had happened to his father would not happen again anymore to anyone in Uruguay and elsewhere. So that was his vision of what we call nunca más, or never again. And it was rooted in trying to institutionalize international law, international human rights law, international criminal law protections into domestic systems. And as we will see during my presentation, unfortunately in Uruguay, these did not happen yet, notwithstanding many efforts that he and others, of course, undertook. So let's go back to the year 2000, 2001. He realizes that it's important to use the new movement towards an international criminal court to create guarantees for the non-repetition of the atrocity of the past, which is in and of itself a modality of reparation. How many of you studied the law on reparations? Probably only those who took human rights courses or international law courses. But let's say that there are 5 main modalities to reparate gross human rights abuses: restitution, compensation, rehabilitation, guarantees of non-repetition and satisfaction, which mainly applies to state-to-state relations. And these guarantees of non-repetition include the fact that you create a legal framework that makes sure that the crimes of the past will not occur anymore in the future. So what happens is that is then participant actively until the summer of 2002, our winter in reality, in the process that leads finally Uruguay to deposit the instrument of ratification and become the 72nd nation state to join the Rome Statute of the ICC. At that point in time, the entry into force, we thought a lot of things will change. Now the focus will need to switch on domestic implementation. And then that's where he had a specific strategy, which was, let's make sure that we incorporate into the law of Uruguay those very same atrocity crimes that, you know, we accepted, because Uruguay was one of the very few non-European nations who had ratified the London Agreement establishing an international military tribunal at Nuremberg in 1945. So Uruguay was already committed to these principles. You may argue that through the incorporation of customary norms into the domestic legal order, crimes against humanity already existed in Uruguayan law during the time of the dictatorship. Yet they had not been consolidated. They had not been incorporated into the penal code. And this is what Felipe aimed at doing in a process that led him to become, in the following legislature, Under Secretary of State for Human Rights from 2005 to 2009, and as essentially his first major project, have already in 2006, a law to implement the Rome Statute and create conditions for full cooperation of Uruguay with the court. This was the first comprehensive law in a Latin American states to implement the Rome Statute, and includes very strong provisions on victims' rights. Of course, this law was a law to implement a treaty that included a principle, the principle of non-retroactivity of the Rome Statute itself. Yet that principle under Part 3 of the Rome Statute, it's in respect of the court. It's part of the law of the court. So he didn't worry too much about that very principle, because of course it was very clear in the black letter of the law that that principle was not projected towards member states, which were already, member states had already pre-existing legal obligations stemming from Nuremberg, the Genocide Convention of 1948, the Geneva Conventions of 1949, all the other treaties, including the Torture Convention and so on, that accumulated towards the decades to form a body of international criminal law. So he didn't think that this could pose any challenge, and continued in the first legislature as a parliamentarian, and in his experience as a member of the executive, to use every possible tool to project this fight against impunity domestically and within the international framework. Just let me also tell you, in 2002, we were confronted with the sort of problem in Parliamentarians for Global Action. I'm speaking now to maybe a lot of you who are interested in taking jobs with the non-profit sector, NGOs, and so on. Well, we were confronted with the fact, well, we have been running a global campaign for the entry into force of this treaty. What do we do next? And Felipe was among the 2 members of parliament worldwide. We consulted hundreds of them, but 2 of them had a good idea. And one of them was Felipe. Said, what we need now is parliamentary engagement. So unfortunately, at that, maybe for those who study international law, I invite you to read authors who wrote towards the end of the 1990s, the decade of international law. At that time, the biggest criticism on the progressive development and codification of international law was there is a democratic deficit of international institutions. The United Nations, the European Union, the Organization of American States, all these bodies, they lack legitimacy because they speak the voice of the executive branches of governments, some elites. They don't represent the people. So there was a movement to create parliamentary assemblies attached to international organizations. The first model was the Parliamentary Assembly of the Council of Europe, which has a discrete power, the election of the judges of the European Court of Human Rights, which is the most prolific international court as of today, the one that has the largest production in terms of judgments. So the idea of Felipe was, let's create a parliamentary assembly for the International Criminal Court. He was supported immediately by a Dutch member of parliament, Gerrit van Hoven. And I said, yes, a de facto one, because de jure, this treaty is almost unamendable. So let's fly law. And he immediately said, of course. And then we decided on the name, the Consultative Assembly of Parliamentarians on the ICC and the rule of law. Met in Ottawa in 2002, still exists. And some of the pictures that you will see later on relate to a meeting in Rome in 2012 that was populated by more than 300 people that took place thanks to the leadership of Felipe as a board member of the organization. That project is ongoing. For those who study the law of international organizations, I invite you to read the big book of Professor Skemmers and Blocher, International Institutional Law, which is the only monography on the law of international organization that treats the role of parliaments and congresses in international relations, describing very much in detail the different powers and capacities attributed by founding instruments to these bodies, and also describing the work of Parliamentarians for Global Action as a parliamentary NGO. All in all, what Felipe believed in is what many people describe in a sort of decreasing, with giving to it a decreasing value, the concept of parliamentary diplomacy. I mean, and most commentaries will be, and it's a big talk show. Nobody does anything, everybody speaks, nothing happens. This is unfortunately the scenario of the largest interparliamentary institution, but it's also a necessary one because it's the only one where you have all the parliaments of the world and all their representatives talking to each other, which is in and of itself a value, correct? Especially in a planet in which we have 56, 57, 58 armed conflicts today, depending on the evaluation. So that role of the interparliamentary union remains essential. But more than diplomacy, I would call it international parliamentary action. And as a spin-off of that project of 2002, Felipe, when he returned to parliament after his experience as as a member of the executive, as a Secretary of State, Under Secretary of State for Human Rights of Uruguay, and also culture, not only human rights. And he represented Uruguay at UNESCO. He created a regional working group on the fight against impunity in Latin America, where the main goal was to promote legislative efforts, exchange views on strategies concerning litigation. And this is probably where his attention was, especially in the last years of his life, because the history of the fight against impunity in Uruguay, regretfully, is not a positive one. It has been characterized by an amnesty law in 1985, and above all, what has been named Ley de Caducidad, law of expiry of 1986, through which essentially the transitional government that took over from the dictatorship decided that there was no cause for action for acts of the past committed in the framework of the repression based on ideology, political motivations, and so on. Only economic crimes were not covered by this Ley de Caducidad, and only the executive could have decided to search for the disappeared, the desaparecidos, in ways and means that would be left over to the evaluation of the executive, which led to a very scarce, insufficient, selective practice of trying to end the impunity of those who masterminded Plan Condor in the 1970s and carried out hundreds of thousands of attacks against civilians, unarmed, and led to almost 15% of the population of Uruguay to leave or to seek refuge in neighboring countries during the years of the repression. There are different sources, but I mean, we're talking about more than 200,000. The population was 2.5 million at that time. So and these are, many observers are speaking about this being an underestimation. So we're talking about really a 10, 15% of the population who left or was obliged or was detained. There is one scholar, Francesca Lessa, who speaks about the fact that Uruguay, at the beginning of the repression, at a certain point in time, around 1975, 76, at the highest number of incarcerated person vis-a-vis the amount of the national population. And this went a lot under the radars, because Uruguay was considered the Switzerland of Latin America, correct? And still is to a certain extent. And so it went less, and maybe other facts that happened later on helped Uruguay to maintain, again, a different profile than others. So what happened when Felipe came back to parliament? And this is something I reconstructed through the literature more than my own personal recollections, because again, he was using parliamentarians for global action and my expertise in international law to go global. That was his goal. When we were meeting, it was all about strategizing what to do vis-a-vis Latin America, the rest of the world, the International Criminal Court. In 2010, he was our main representative on behalf of our board in the Kampala Review Conference on the Rome Statute, which made an historic decision, because the biggest problem in terms of the principle of legality of the Nuremberg legacy is that the crime of aggression or crimes against the peace are not defined in the London Charter, right? For those who studied it, remember it, essentially the London Charter criminalizes those who execute, plan, conduct, launch, wage a war of aggression. Oh, aggression is a war of aggression. Crimes against the peace are a war of aggression without giving the elements of it, right? Of course, everybody knew what was a war of aggression after World War II. We had seen the Axis powers, Nazi Germany, fascist Italy, imperialistic Japan, trying to invade all the rest of the world. and that was the mother of all the crimes. You study a lot human rights law at the Institute for the Study of Human Rights, at the Human Rights Institute here at Columbia Law School. That's wonderful. I admire you. Remember that the core crimes under international law, they're not 3. They're not crimes against humanity, war crimes, and genocide. There are 4. The 4th is as equal, even if not higher standing in history. Because the only reason why Nuremberg is legitimate, it's because the aggression was committed by my own country, Italy, Nazi Germany, and imperialistic Japan. And victim states were the rest of Europe, North Africa, Asia, China, Southeast Asia, the Philippines, all invaded by, including the United States in Pearl Harbor, correct? So that is the real crime that makes Nuremberg legitimate, because you have a victim and you have an aggressor, all right? If you look at the rest, a lot more can be said, and Justice Robert Jackson, who was the prosecutor at Nuremberg, the Supreme Court judge on the US Supreme Court, said, we will be, the same law that applies to you will be measured against us, because of course, Justice Jackson, as all of you who are law students, or most of you are law students, you know that any legal system, to be credible, has to be founded upon one legal principle that Felipe mentioned several times in his speeches, the equality of all before the law. All right, so those who want to be more equal than others go outside of the rule of law. And unfortunately, that's what we're trying to witness today in many circumstances. So these lessons are still valid. So when in Kampala, Felipe Michelini was with the Parliamentarians to Global Action. We had organized our Consultative Assembly of Parliamentarians. Then we brought the delegates into the room. He was interacting with government. Of course, we're talking about a member of parliament with access that none of us can imagine. No, of course, he's an elected official. He has a dual capacity. The second week of the conference starts, and he wakes me up and tells me, David, our ambassador flew back to Johannesburg. Uruguay is not present anymore in the room. I said to him, no, we need a quorum. What if there is a vote at the end of this conference? Uruguay was one of the good states. Yes, I'm going to do something. I'm going to write to my foreign ministry and ask to be the Uruguayan delegate. That happened in the matter of a few hours. I think he woke up someone in Montevideo for sure. And he represented Uruguay in the second week of Kampala, when the Kampala Review Conference ended, including with the adoption of Article 8 bis of the Rome Statute, defining for the first time in history the crime of aggression. I invite you to read Article 8 bis of the Rome Statute. Felipe commented, the crime of aggression is one of the 4 of the most serious crimes under international law, as recognized since 1998 in Article 5 of the Rome Statute, which was already ratified by Uruguay. The adoption of the definition of the crime in Kampala constitutes an historic legal development since 1945. Uruguay, so he's speaking now as the head of the delegation on behalf of the state, Uruguay joins in the efforts of PGA members in Argentina and Chile, humble approach to defer to his colleagues there in the room representing parliaments, to be at the forefront in ensuring full support to the respect of the principle of equality and rule of law enshrined in the Rome Statute and in the UN Charter in Latin America. So he had already in mind, let's then create a regional action. He had already in mind what to do next. Let's take these amendments, create a movement in Latin America towards ratification. That plan was made. He launched it the year after. Since 2013, we had more than one meeting, sometimes even twice per year, in Montevideo and in Central America or other hubs, including Quito, Ecuador, to promote the ratification of the amendments. So the crime of aggression is part and parcel, according to Felipe, of international criminal law, and the fight against impunity must encompass it. This job is still unfinished as of today, because last July we witnessed a conference on the amendment of the amendments, and a tiny minority of states managed to block the entire decision-making process. And this was led by some of the major states, France, the UK, Canada, that aligned with the demands also of the United States, which intervened as a non-state party, requesting that this reform did not take place. Because unfortunately, the Kampala Compromise entails that only through a Security Council referral can the ICC jurisdiction be activated. And Article 15 bis includes a carve-out, an exclusion from the jurisdiction of the ICC of any nationals of non-state parties. And this is the carve-out clause that President Vladimir Putin is exploiting vis-a-vis the current case of the aggression against Ukraine. And that's why the Council of Europe had to come up in June with an agreement with Ukraine to create a special tribunal, an ad hoc tribunal for the crime of aggression. So what happened after 2010 was also when he went back to parliament, not only to promote the Kampala amendments, but also to change the legislative landscape in Uruguay to make sure that the law of expiry would have been nullified. And this was the goal of law 18,831. I don't know why in Uruguay they have these incredible numbers for laws, but that's what I need to cite. And the idea was in that law to stipulate, in essence, that there is no statute of limitations for crimes against humanity. And what had been enacted in '86 was unconstitutional, clearly, as it was. In 2012, and you have a number of pictures that I will show you later on if there is time for exchanges. In 2012, he addressed the CAP ICC in Rome. And in 2013, however, he was furious. And he wrote a very important piece in the human rights briefs of the Washington College of Law at American University, in which he commented on a Supreme Court of Justice, the Supreme Court of Uruguay, decision to instead declare the Articles 2 and 3 of this law 18,831 unconstitutional, because these articles allegedly violated some principle of law, not included in the Constitution, but in the penal code, as well as in the penal codes of Italy from the 19th century, or the Granducci of Tuscany. I mean, I invite you to read that judgment because it's an incredible aberration of how constitutional court can subvert the law for political purposes, and essentially declaring that under this notion of a very strict understanding of the principle of legality, Uruguay could not apply the law on crimes against humanity to the 1970s and 1980s events. This essentially is a status quo that continues to exist today. When Felipe, after that he left, so he was in parliament at that time. When he left parliament, he assumed other roles, including chairing the working group for truth and justice, an entity, a sui generis entity set up by the President of the Republic of Uruguay to deal with the problem of the impunity of the past. And in that capacity, he worked with a lot of victims associations, civil society organizations, towards removing obstacles that the Supreme Court had put forward, trying to support strategies of litigation across the borders of Uruguay. Of course, there has been trials for leaders, including a former head of state of Uruguay, because the amnesty laws and the ley de caducidad would not apply to crimes committed in Argentina's territory. So there was that loophole to a certain extent that was used. And he also, and then this dates back to when he was Under Secretary of State, he also supported a trial that took place in Rome, Italy, my own country, my own city, where for the first time, victims, and this was on the basis of invoking the principle of passive personality, they were Uruguayan Italians, were able to put forward the entire victims from different dual nationality backgrounds, Uruguay, Argentina, Bolivia, and so on, were able to put forward all together a case that the Office of the Prosecutor General took up, which led in 2017, and then on with the appeals chamber confirmation in 2019, and later on with the Court of Cassation further confirmation in 2021, which led a first overall judgment of the transnational Condor, the criminality of the transnational Condor plan. This is not so well known. And I really invite you, if you want to know more about Felipe's, also in terms of his style of communication, which is so down to earth, is so friendly, so easy to access. If you speak Spanish, of course. If you don't, then it's going to be difficult. But there is, on the 10th of July 2019, he gave an extraordinary interview to Radio Mundo en Perspectiva. It's on YouTube, in which he shared his vision of the previous 30 years, essentially. As a starting point, there was that judgment that is so important because not only the top leaders are convicted, but also the mid-level torturers. And the main case that triggered this entire thing was Troccoli, the case against Mr. Troccoli, an Italian Uruguayan who had wrote a book saying, well, this book was saying essentially, well, I didn't kill anyone, I just tortured, okay? He was convicted for aggravated murder, by the way. He was found guilty of aggravated murder, not only torture, under Italian law, because that's what national courts apply, they apply national law. But in an obiter dictum, already in the first judgment, in the second and in the final one, the Italian judiciary says these are crimes against humanity. Crimes against humanity that exist under customary international law since 1945. The perpetrator had a moral choice, including these middle-level persons that have been covered up, according to Felipe, by a pacto mafioso, a pact of absolute silence between those who took the power after the dictatorship and those who had committed the atrocities in the 70s and the 80s, to cover up all the facts of the past in the name of a new Uruguay. And without this emphasis that I use here, very much using a tone that was proper to him, he explains how step by step, year after year, victim by victim, he mentions the names, of course, I wouldn't make justice here of their role. Aurora Meloni, Cristina Miura, Daniel Banfi, Bernardo Arnone, all these survivors, or those who lost their relatives, they had the courage to bring the claims. And the key moment was after Judge Baltasar Garzón, after the adoption of the Rome Statute. In a conversation I had with him, I asked him, why did you do what you did against Pinochet in September 1998? And he told me, well, we had the case already prepared. In reality, we were expected him to travel sooner or later, of course. But we saw what had happened on the 17th of July in Rome. The adoption of the Rome Statute means the era of impunity is finished. It's a crystallization in a treaty of what we consider customary law. And you have then that very important, and that triggered so many others to come forward with claims against, torturers, dictators, and so on, not only from Chile, but also from the rest of Latin America. So in that interview, he expresses a final statement. I want to cite it. All that we have done, all the efforts, legislative, advocacy, judiciary, international, are all against one vision, and only against one vision, that vision, we must assess his legacy. Contribuir a la institucionalidad de la lucha contra la impunidad. To contribute to institutionalizing the fight against impunity at all possible levels, in all possible grades. I think the fight is still on. We still have so much to accomplish. So I will, maybe we have 10 minutes for a conversation, but I should have said much more, and I really thank you for this opportunity.
Thank you so much for talking about Felipe and his legacy. I'd like to open it up to questions, please. Comments, questions, please.
Yeah, you mentioned Justice Jackson, and I think at the Nuremberg trials, he said something along the lines of, this is the greatest tribute power has ever paid to reason. And I think that's kind of fundamentally the issue that all of these weighty concerns kind of bring to the table. What gives you hope that in a world with so many armed conflicts, power will ever pay tribute to reason in that way again?
Well, I think I speak here as a foreigner, correct? I'm not American, but I've seen a major achievement recently, you know, a ceasefire agreement, correct? That ceasefire agreement was co-signed, was co-agreed upon by an individual who is under an arrest warrant for war crimes and crimes against humanity. Am I right? Starvation and very serious. So you see, it happened notwithstanding the fact that we had this International Criminal Court decision that created outrage, in the words of former President Biden. And then I can also mention other words that have been said later, but I would spare you, much worse. So the reality is that this is what I call the principle of inevitability. There is a law, whether we like it or not. This is what also it's basically the idea of the supremacy of the law. The law is above politics. And in Uruguay, let me tell you something. In Uruguay, they made 2 referenda on whether to get rid of the amnesty law and the ley de caducidad. In one referendum, which was in the early days, 52% of the voters voted to safeguard the amnesty laws. In another vote, there was no quorum. So it was also a defeat. And I invite you to read the jurisprudence of the Inter-American Court of Human Rights. In the Gelman case of 2011, Macarena Gelman is a survivor of the dirty war. Her mother was killed after that, she was arbitrarily detained, tortured. Macarena was born in captivity and given to a family of Argentinians, whereby the mother and the father had been killed already, and then the mother also was killed during the dirty war. And in that decision, the Inter-American Court of Human Rights says, yes, it is true that Uruguayan people voted. So there is some sort of a legitimacy of the current status quo. Yet, the law, yes, we cannot accept the dictatorship of the majority. The law is there to protect the minorities by definition, those who have suffered, and those human rights are inalienable. They cannot be removed from them. They have a right to justice, a right to truth. So even in the most difficult circumstances, the principles stand and will continue to stand. So I think that's the vision for the long term. Still, Justice Jackson was right all over. Yeah.
Thank you for a very interesting presentation. If it was in your power, what would be the next law of international law that you would initiate?
Oh, wow. And one of those, I don't practice law, but I really like drafting. I think we are a minority, those who like to draft. I invite you next Saturday at the International Weekend of the American branch of the International Association at Fordham Law. We discuss in a panel crimes against the environment. We have a proposal to include crimes against the environment within the draft articles on crimes against humanity for a new treaty that the process of which should culminate in a diplomatic conference 2029 decided by the UN. Too much information. If I had the possibility to choose, I would say that the major obstacle to the implementation, to the application of international criminal law should be removed. And this is the personal immunities of sitting heads of states. We have, under domestic law, you can impeach a president for corruption. In most national systems, you can, do a lot of things. But internationally, we have this idea that sitting head of state, stemming from the equality of states and the Congo versus Belgium judgment of the ICJ, they're essentially, as long as they're in office, they're untouchables, right? And this creates an incentive for those who are in office to be in office forever. Look at Putin and the leader of the People's Republic of China. They aim to live forever and be forever, right? So this is a sort of very criminogenic rule. It's a rule of law, but instead of addressing the problem, it amplifies it. So we need to find a way. Maybe the main problem is that we don't want abuses of power. We don't want any court of any state to prosecute any unfriendly head of state, all right? So we need to create some sort of a camera, a chamber somewhere that will filter these, the genuineness of domestic efforts to end impunity, including the one carried out domestically, but we're not there. It's a long-term goal.
Hi, my question is, so I know that the Pinochet trial began through Spain, and you just mentioned now how a lot of people involved in the Uruguayan dictatorship were prosecuted in Italy. Understanding obviously that the relationship between Italy and Latin America and Spain and Latin America are very different, I was wondering if you think that there is a tension about the prosecution of these war criminals happening neither in the domestic country nor in some kind of neutral international court, but in the domestic court of a Western power?
Well, the option of an international court is not there because these international jurisdictions are always non-retroactive by definition. This is, whether we like it or not, that's the reality of international law. An exception was made probably when we had the revolution, which was Nuremberg, but we had the pre-existing laws on war crimes, for sure. We had post-World War I documents that were not acted upon, but they were dictating certain basic principles of law. So it was possible to do so and to change. In moments of change, you somehow apply the law also retrospectively when needed. This was all a bottom-up process. The victims came forward in these jurisdictions. So, Felipe Michelini, like me, we could not just, our role was and continues to be to support these efforts. Abuses of powers are so pervasive that I don't believe we shouldn't search for any politically correctness in the response, all right? Whatever is available should be exploited up to the maximum. Of course, we still want to see, and that was Felipe's goal, as a chairman of the working group on truth and justice, he was engaged before the elections between 2019 and 2020 to try to get a piece of legislation removing the impediments to the exercise of jurisdiction within Uruguay. And that, I think, it's a process that could not be accomplished, and then he passed away. Certainly, that would be a project he would be still embarking on. And then you have jurisprudence. So then that's where you, as I don't know if you are a law student, perfect, then you are in the right place, because judges do not misinterpret the law forever. There will be judges, and there was already a minority, who will be more rigorous and less politically motivated. And we know that many times the law is unfair, so we need to live with it. But in this case, Uruguay has so many, is part of, international law is part and parcel of the law of Uruguay under the constitution, including human rights law. I mentioned to you the scholarship of an international relations professor from the right wing who got President Sanguinetti at that time who came from that agreement to cover up for the crimes, that for the future we can join. And they joined against the opinion of then Foreign Minister Operti, for example. So you have spaces, you have avenues through which the law can apply and create, harmony in society between those who are moderately conservative and those who are open to, I wouldn't say progress, I would say to apply the law as it is. Yeah, I think so. Law students, scholars, judges, lawyers have an enormous role to play.
For everyone, unfortunately, we've run out of time, but for those students who registered to continue a conversation.
May I say something before the end? May I say something before the end? So we have, I think, connected with us, but we don't see him, the son of Felipe, who is a brilliant law student in UDELAR, Universidad de la República, and he won the moot court competition at the ICC of the Spanish-speaking countries. So, I mean, big responsibility on his side, but we share it with him to make sure that we continue to fight for the right cause.
So everyone, those who registered to continue at a coffee chat at the law school, it will be on the 9th floor after this. Yes, I'd like to thank, first of all, you, Professor, for coming and speaking about Felipe and his legacy, and to everyone who spent an hour with us today. Thank you so much.